Sunny welcome from Lincoln's Inn from me, and from the Dark Star from Piers.
Come on, hurry.
Who's going to contribute?
Did you not get
I don't know if he's going to contribute the whole of this broadcast in the as a stormtrooper, but he's also a socially distanced stormtrooper. You can see with his mask on. So we are reflecting these strange times, even when we're dressed up as stormtroopers.
Did you not get the memo about fancy dress, Obi-Wan?
Yeah, I know, quite.
The rest of
we
us
can't see the crowd.
Are all in
It
Star
may be
Wars
that
kit. You've embarrassed yourself. I'm sorry.
I have, no, and it may be that throughout the world, people are watching us dressed up in fancy dress, and I'm the only one, of course, stuck in Lincoln's Inn.
You'll see it's also a protest against lockdown on behalf of Jonathan Sumption. You get the political aspect.
What we're doing today is talking about unraveling trustee mistakes. And the plan is for me to set the background and then for Piers to bring you up to date with the most recent developments that are going on in the courts. And what this chat about is really about rescission, trustee rescission. That's what we're going to focus on. But don't forget rectification. Rectification really is the lodestar. It's the alchemist's dream, because if you can get rectification, you don't just undo, you put things right and you get things completely changed the way you want them. Rescission, all it does is undo the mistake you've made. It puts you back to where so you haven't got your mistake sitting like an albatross around your neck, but you may not be any further forward down the lane. If you can get rectification, then you may find actually you've not just undone the mistake, but you put yourself exactly where you want to be. Rectification much less likely among trustee mistakes, we reckon. Rectification is where you've looked at it and thought, oh no, I meant to do something completely different. Whereas rescission is, oh no, I didn't mean to do that at all. And although that doesn't give you an exact definition of what we're talking about, it conjures up the difference. Rectification is where the document itself doesn't reflect the intention of the person who made it. Normally, with the trustee, it will. But sometimes just keep an eye on that possibility, because sometimes the trustee has got a different mindset than the beneficiary, who the trustee is trying to assist and help. And the beneficiary requested a particular action, the trustee did something very different. And in those circumstances, it's sometimes possible to sneak rectification through. But back onto rescission, and we start with the basic duties of trustees. The trustees have a duty to take into account when they're making decisions, all factors which they ought to take into account. They must not take into account considerations which they should not have taken into account. They must not be perverse. That's a lovely little twist at the end. Perverse is not quite the same as perverted. I did do one case where, as trustee, we surrendered our discretions to Mr. Justice Harman, sometimes thought of as a bold move to take. And when he had the joy of exercising the trustee's discretions afresh, he turned to Terry Etherton, who was leading for one of the parties, and says, has your client got any perversions I ought to know about, Mr. Etherton? So not that sort of perversion. It's perverse. They mustn't be perverse. They mustn't take a decision for a reason which is just wholly bonkers or unsupportable. That's the basic framework, which takes us to the rule in, as you've guessed, Hastings Bass. A picture is worth 1,000 words, so you've got 2,000 on this page. And the Hastings family, an old family, who married into the Bass Brewery, into the beerage, I think around about 1900 or so, to revive the family's fortunes. But they trace descent from Robin Hood. And each member of the family, male member of the family, has got the names Robin Hood as their middle names, or they certainly used to. Claire Balding, member of the family, her mother was a Hastings Bass. But the Hastings Bass jurisdiction was one, as you all know, it was one of the great common law jurisdictions. it was developed by the common law in that wonderful way the common law has of incrementally adapting and changing, developing the law. And for some 40 years or so, built on a decision by a brilliant jurist, Sir Dennis Buckley, Lord Justice Buckley, whose father had been Master of the Rolls, so he took the law in with his mother's milk. The Hastings-Bass jurisdiction was really well established, but it seems a feature of the common law. And there are a number of cases where it was applied to set aside a trustee's decision. But it is also a feature of the common law that a different court further on down the line seems to be able to go back 40 years and say, you made a mistake 40 years ago. And despite the fact the common law has developed swimmingly ever since, we're going to unpick that particular bit of weaving and try and turn it over, try and reverse 40 years. And the Supreme Court did that in the conjoined cases of Futter and Pitt and Holt. In theory, they're about different things. Futter was about fiduciary mistake when considering exercising fiduciary powers. Pitt was about an individual's mistake, although the individual was also a receiver, so had fiduciary duties. But we'll see that because really of the difference in the facts of the two cases, we have a strangely Janus-like decision, which looks back and then looks forward. It seems to close one door, but by gosh, it opened another door. So let's see how that developed. Futter, relatively straightforward case, offshore trust, settlor with his own losses, stockpile gains offshore. And those gains were triggered by the trustees in the hope that the settlor's losses would be set off against the stockpile gains. Apparently, Section 2, subsection 4, Taxation and Chargeable Gains Act 1992 says, no, you can't do that. And that was overlooked. So the trustees went to court to ask if they could revisit, if they could rescind that decision. And it was essentially a vanilla Hastings-Bass. The judge set it aside in the way that they always did. But there was a strange, growing reluctance among the judiciary to see this happen, and I don't know why. It is one of the comforting things about the jurisdiction that the mistakes, when they hit the courts, tend to be about the bigger cases, and so tend to involve the better firms of solicitors. And this particular case was particularly comforting because the solicitor involved is one of the best private client solicitors in the business. So when you worry about making mistakes yourself, you know that you'll be in good company if you do. The Supreme Court decided that the case, it couldn't be set aside. As you well know, they decided that if there was no breach of trust, the Hastings-Bass jurisdiction was not engaged. And so there was no breach of trust because the trustees took advice, which is what trustees are supposed to do. And even though they got the decision wrong, because they'd taken the advice, they weren't in breach of trust as trustees. Slightly odd that they took advice from themselves. The trustee was a specialist trustee with private client experience who had been appointed for just that reason. And his department gave the advice. So a strange little dichotomy there, which I'm not sure I quite understood. But it was a reflection of the fact that the Supreme Court thought that the jurisdiction was too soft, too friendly to beneficiaries and trustees. What was left of Hastings-Bass after that? In theory, it looked like not very much. Excessive execution, where you've tried to execute your powers beyond the scope of those powers. You've done something which infringes the rule against perpetuities, which is quite an achievement nowadays, or you've exercised your powers beyond their focus and scope. Breach of trust is still obviously within the rule in Hastings-Bass, where the trustees haven't taken advice, and that does happen. We'll see some examples of that perhaps later on. And fraud on the power is also a surviving element of the jurisdiction, but fraud on the power is not really what Hastings-Bass is about at all anyway, so that's limited comfort. But how did the offshore world respond to that? And it is a sad fact, I think, of the modern development of the private client common law in this country that we are getting left behind. The offshore jurisdictions quickly reintroduced the old Hastings-Bass jurisdiction in statutory form. In certain places, Jersey did it, you can see there. I've set out a number of the recent cases where they've done that, and a brilliant article by Damien Evans of OGA in the TQR, which covers those recent three. Well worth a look. Particularly exciting, I think, because D&E Trusts, which is the Vortex case, where rather splendidly the clever minds that brought to bear on how to mitigate the tax in those trusts managed to transfer all the assets into two companies which each owned each other and therefore were owned by absolutely nobody. And by God, they needed to get out of that particular vortex. And I've also left in the name The Great Escape, just because it is an obviously relevant name for cases of this kind. So Jersey introduced statutory jurisdiction, Bermuda did, and Bahamas did as well. The Guernsey haven't. Guernsey have been following Pitt and Holt in the Supreme Court, and we'll get a glance at that later on. And Isle of Man hasn't introduced statutory jurisdiction, but the last thing I heard from the Isle of Man, and maybe somebody out there can help with this, was that they were not following Pitt and Holt in the Supreme Court. But whether that still holds, I'm not quite sure. So that was the offshore reaction. The opposite side of the coin, in the sense of Hastings-Bass, was individual rescission. And that was encapsulated in the older case of Gibbon and Mitchell, where somebody had unwittingly triggered the discretionary trust for protective trust, and Mr. Justice Millett set aside that. It was a jurisdiction under which a transaction would be set aside if it did not have the effect that had been intended. But it was always true under Gibbon and Mitchell, the Gibbon and Mitchell jurisdiction, that a tax mistake itself was not enough. Tax was a consequence, not an effect, and you wouldn't set aside for tax. But in Pitt and Holt, the conjoined case with Fata, the Supreme Court said, no, we're going to create a new test for Gibbons and Mitchell. We're going to adopt it. We're going to improve it, and that is, there should be a mistake as to the legal effect or an existing fact. The mistake should be sufficiently grave to engage a rescission remedy. But a tax mistake is now enough to trigger that remedy, which was a huge and useful development. And the effect of that has actually been very, very useful. Quickly look at the facts, see how that arose. Derek Pitt had been involved in a very bad car accident in 1990, awarded £800,000 compensation, which was pretty much top dollar for back in those days. On IFA advice and under the order of a court of protection, goodness knows what they were doing, the wife placed all the compensation money into discretionary trust, which triggered an immediate charge to IHT, wholly unnecessarily. Nobody spotted it at the time. Court of protection told her to do it effectively. She did it and blithely carried on. The mistake was only covered shortly before Derek's death in 2007, when £6,259 was left. So a seemingly disastrous result in very, very sad circumstances. No question of tax arrangements, no question of offshore, a very, very sad case. Sad cases make hard law, and sad cases make good law on this occasion. The Supreme Court said the mistake must be of a sufficient gravity to invoke the jurisdiction to be set aside. Then all, to quote, must be under some mistakes of so serious a character as to render unjust for the donee to attain it. So serious character of the mistake, unjust, unconscionable for the donee to attain. And exceptionally may even be as to tax. So there's some old cases which are still good law, the Ankepeton case, where the beneficiaries assigned from a very simple life interest will trust that their father set up into a very, very refined, complex, offshore Jersey trust with all the bells and whistles you might need, with discretions lots of discretion vested in the trustees. That's what they did as part of a huge variation of the family trusts, and were absolutely astonished to discover within 3 months of that variation that the trustees were able to turn off their income supply, which had been a fixed interest, on the back of a signature they'd written on documents at an airport when a junior solicitor had flown in and flown out. So that's Anchor Peterson. Wolf and Wolf, another one really helpful case, a reversion release tax planning scheme, which turned out to be unattractive for tax reasons, and it was unraveled because the clients hadn't understood it. No client could understand a reversion release scheme, so that was a well encouraging rescission case, and these are still good law. The important thing about Pitt and Holt, though, is you've got to get your round peg into the round hole, and you've got to get the square peg into the square hole. So you've got to work out exactly which category of mistake you are. And the Supreme Court gave us 4 categories, 4 shaped holes and 4 shaped pegs. Incorrect conscious belief, incorrect tacit assumption. Those two will allow you to engage the jurisdiction of rescission and allow the court to rescind. But if you were mere causative ignorance or misprediction as a future event, you won't be able to engage the jurisdiction. Now, I do not see myself how you can get a credit card between those various categories. And a fine example of that can be seen in the case of Ree Griffiths. There, the client involved had terminal cancer, but did not know it. And he took various steps to transfer assets. He thought more than 7 years before he was likely to die. But sadly was, as with people who often take those sort of tax planning schemes, dead within the year. Was that an incorrect conscious belief on his part that he was wholly strong and well? Was it an incorrect tacit assumption that he'd be likely to live for the next 7 years? Or was it mere causative ignorance of his underlying cancer? Impossible to say, actually, and views rather differ according to whom you ask. So that's those are the categories we look at. You need to fit into the green categories, not the red ones, and you need it to be unconscionable for it not to be set aside. Piers, you're not wearing your stormtrooper helmet any longer, so can I hand over to you to take us further on?
I'm not sure which of Newton's laws it is that dictates that the older that you get, the faster time seems to pass, but I can't quite believe that it's already 10 years since Alistair Norris decided Pitt and Holt at first instance. The Supreme Court decision was in 2013, and it took a couple of years for the first reported decisions to filter out. But I'm no doubt that many of you, as I was, had been using it before masters as soon as it was off the press in order to rewind the video and piece back together a trust fund that had crossed a road without noticing a tax juggernaut. The first reported cases, though, were in 2015. And first I'll look at his right and the National Westminster Bank, which was another decision of Alistair Norris, who had been reversed in Pitt and Holt. He was undoing transfers into discretionary trust by a husband and wife. The trust was settled by the husband, and his letter of wishes said apply income and capital for the benefit of the wife to meet her needs if required. The effect of the trust provisions, however, was that she could not receive any income from the trust during his life, nor even after his death. They notified the revenue, and the revenue just wrote a letter asking them to refer to the court to Pitt and Holt. So here's our first practical note, which is that one doesn't have to join the revenue as a defendant initially. because one is not seeking relief directly against them, but one should write to the revenue as they are obviously affected by the relief you're seeking. The application should by that stage be ready to on the stocks and ready to go, so that one can send them it and all the supporting evidence to consider. If the revenue wants to be joined these days, when the jurisdiction is pretty well defined, then it looks like one is in for a rocky ride. So one will want to check and recheck very carefully whether the joins in the case are going to stand up to testing. If the revenue don't want to be joined, obviously this is good news, but one is still far from home. And as Alistair Norris said in the unopposed application in Wright and Nat West, the court must nonetheless be satisfied that the facts are proved such that the jurisdiction is available and appropriate to exercise. It's not a proceeding by consent. The case must be proved as for retrospective rectification. I would have added that these applications are almost invariably being used to avoid a tax charge, and the taxes pay for the courts. So one can understandably expect that Cerberus's three heads are all going to be lively and awake in checking whether one has satisfied the criteria for that. I would suggest lodging your letter to the revenue and your answer with the application, as this is the first thing that the master will check. And if one doesn't produce it on the first appointment on your application is going to be adjourned until that correspondence has taken place. I have had a case and seen other cases in which the revenue failed to reply, and the court was happy to proceed on the basis of no response by the revenue to a chaser saying, unless you respond by a reasonable deadline, we will proceed on the basis that you don't wish to be joined and don't wish the court's attention to be drawn to any particular case. These days, however, they do seem to be better about responding. In the Wright case, the application to rescind was unopposed by the adult beneficiaries of the trust that the property was being taken back from. There was one appointed to represent also the minor and unborn potential beneficiaries, and they took the advice of counsel, who advised it was not in their interest to resist. So a second practical note is that minors and unborns affected should have representation, and that representative should be advised by counsel. Alistair Norris considered the three criteria that Tom has talked about: seriousness, causative effect, and unconscionability. He said that a unilateral mistake of a settlor is sufficient to set aside a gift, and referred back to a decision called Maskell and Denham, but predated Pitt and Holt, which was a decision of Morritt, citing Gibbon and Mitchell. And as we've heard, what is required is a causative mistake that is so grave that it's unconscionable to refuse relief. That mistake must be as to the legal character of the transaction, quite difficult, or more helpfully, a matter of fact or law that is basic to the transaction. And the court will assess the gravity, Norris said, of that mistake by a close examination of the facts and circumstances and the centrality of the mistake to the transaction and the seriousness of the consequences. Then the court must make a value judgment as to the unconscionability or injustice of leaving the mistake uncorrected. So he made a detailed examination of the evidence, which included advice received from the bank that the wife would be able to benefit from income and capital. And again, third practical note, you need detailed factual and witness evidence of the kind as to how the mistake was made, of the kind that would stand up in hostile proceedings. And the more documentary evidence you've got, the better. It was accepted in that case, and this is the first of a number of cases in which the mistake was actually pointed out to the relevant party, but the relevant party just had a blind spot, just couldn't see the wood for the trees, and the relief was nonetheless granted. It was accepted that there was a letter pointing out that income and capital couldn't go to the spouse, but that letter just hadn't been understood, and indeed had been contradicted by subsequent incorrect information. So the mistake was established in spite of that, and it was held to be grave because the couple relied on receiving income to maintain their standard of living, and they wouldn't have made the transfer into the trust had they known, because they would not have that money to live on, and therefore it's unconscionable. I mean, we can say, and we're going to come on to this complexity, that in any of these cases, it's going to be the case that if we'd known then what we know now, obviously we wouldn't have done it, or we wouldn't be here trying to undo it in the first place. So the but-for test is, I would suggest, inevitably going to be satisfied in these cases, because otherwise, what are we doing here trying to undo it if it hadn't been the case that we wouldn't have done it if we knew then what we know now. It was made a condition of relief that corrective income tax returns be made, so as to make sure that the trustee recovered the tax it had paid and the couple paid tax on the income that they would have paid. So all that has to be undone, but the fact that is a sort of little painstaking exercise that has to take place of redoing everything, provided it can be redone, that correction of the income tax position following rescission is not a bar to rescission. Next, so that's right in NatWest. Tom, could you move the slide on, because I still don't seem to have control of that. The next case is, thanks Tom, Kennedy and Kennedy. This is another first instance decision, but a decision of the then Chancellor, Sir Terence Overton, who's now Master of the Rolls, so it carries some judicial wallop and is interesting in a couple of respects that are useful. The applicants were very lucky in their tribunal, because there was a direction they should be available for cross-examination, and they were too grand to turn up or make proper excuses about not turning up, or the excuses they gave the Chancellor found pretty thin, and he was clearly furious, but nonetheless still was persuaded by Mark Herbert QC to crack on and deal with the application rather than make everybody come back and bow and scrape. The first of the interesting aspects of the case is that this was an application by trustees to correct the exercise of the power of appointment, not an application by an individual to rescind a gift. So it confirms that this jurisdiction to rescind dispositions is exercisable in favour of trustees as well as individuals. So that means that while Pitt, as Tom said, restricted Hastings Bass to cases in which the trustee is in breach of trust, thereby very severely limiting its utility and taking away with one hand. On the other hand, it effectively reinstated the jurisdiction to undo exercises of powers based on a mistaken misunderstanding, in particular as to tax consequences, which is what we chiefly tend to be concerned about in these cases, now rooting it in this equitable jurisdiction to relieve parties of the consequences of a mistake, where it would be unconscionable for the recipient to retain the benefit of that mistake to the detriment of another party. And so in the end, the only people who've really lost out by this taking away and giving with either hand were the poor old futters who didn't have their ducks in a row in order to make the application under the new jurisdiction and lost out under the old jurisdiction. So they must be heartily futting sick of the whole thing. As for the rest of us, though, we have the new jurisdiction. A next practical note about Kennedy is that the evidence gave the full background of the tax planning that was involved. Tom mentioned that we're not looking at rectification in this talk, which is another way of remedying trustee mistakes. There's a third way of remedying trustee mistakes we don't like to talk about, which we're not looking at, and I can barely bring myself to mention, and that is compensation. That is when the beneficiaries sue the trustees and trustees sue their advisors to restore the loss caused by the mistake. That is, of course, precisely the sort of unnecessary unpleasantness that this jurisdiction we are examining avoids. But as in Kennedy, and it must be recognised in most of these cases, it is necessary for the solicitors, accountants, other advisors who are involved in the mistake being made to give detailed evidence as to how it was made, with the prospect of undoing the mistake rather than being on the end of the possibly unfortunate, unpleasant consequences of the mistake. So the relevant professionals will need sanction from their insurers for their evidence. Another practical note. And a delicate way has to be found in the evidence of identifying precisely how the mistake was made, referring to the documentary evidence where it is possible without addressing the ticklish issue of culpability. So that is a rather delicate practical aspect of the cooperation required for these applications. In Kennedy, the mistake was one clause of a deed of appointment by trustees, which affected a number of other appointments made in the same deed. This one appointed the remainder of the assets in the settlement after those other appointments, and gave rise to a £650,000 CGT charge. The solicitor who set it up believed that there were losses in the settlement sufficient to offset that charge, but he wasn't aware that the loss had already been applied against another gain. He was trustee of the settlement, and they made this appointment in that mistaken belief. So it was understood that there would be a CGT disposal with a gain, but misunderstood that there were losses to offset that gain. Again, children and grandchildren beneficiaries did not oppose the application. The Revenue reviewed the witness statement and did not oppose. The Chancellor set out the requisite elements in a passage which is very often referred to as a handy summary of the Pitt and Holt requirements. Something we'll come back to is that he highlights that a distinct mistake is required, not what's called mere ignorance, inadvertence, or restitution type, what's called misprediction. So if you make an appointment to someone and they win the lottery the next day, and you say, well, I wouldn't have known it if they knew they were going to win the lottery, wouldn't have done it if I knew they were going to win the lottery the next day. That's a misprediction, and that's not going to found the jurisdiction. It has to be existing circumstances. The Chancellor also emphasised that carelessness, helpfully, is irrelevant. It doesn't matter that you should have seen the mistake, and I've referred already to a case in which the mistake was pointed out, but there was a blind spot. Again, sufficiently grave to make it unconscionable for the donee to retain the property. I'm going to keep coming back to this, the importance of underlining to the court the equitable foundation for the jurisdiction, which is essentially that somebody has ended up with property and they're a volunteer, but for the mistake that's been made by the party that appointed the trustees who appointed it to them, they shouldn't have that property. So it's not fair on the people who've been deprived of their interest in the settlement for that appointee to receive the property. That should have happened by reason of a mistake that shouldn't have been made. Because the recipient is a volunteer, there's an equity to recover it. If the recipient had been equity's darling, had given some sort of consideration, then it'd be a totally different ballgame. The jurisdiction wouldn't exist. But because the recipient is a volunteer, the court can look solely at the mistake in evaluating unfairness, unless the recipient has in some way changed their position. But generally speaking, as we know, to avoid the tax, the recipient's going to be supporting the application. The judge said, the Chancellor said, objectively, the court had to objectively evaluate the injustice, the unconscionability, which he rightly identified, in my view, as being exactly the same, another word for unfairness or injustice. And he said that requires what's called an intense focus on the facts. And you will have noticed that judges tend to couple this rather broad requirement of unconscionability with the requirement for, quote, an intense focus on the facts, because this gives them flexibility. The court looks at the existence of the mistake and its centrality to the disposition and the seriousness of the consequences in determining whether it's unfair. The donee to retain the benefit. Rectification was also sought in that case. As Tom said, again, we're not looking at rectification, but it is worth noting in favour of the rescission jurisdiction that we're looking at, that it is more benign and flexible than the jurisdiction to rectify, particularly in the context of mistakes as to a tax liability. For rectification, you need to show that the trustees had a specific intention as to what they were doing, and the deed or other document executed did not accord with that specific intention. If the deed, however, did what the trustees intended, but by a mistake as to fact or tax law, that what they intended to do incurred a tax liability that they hadn't appreciated, the court will not rectify the deed so as to avoid that tax liability, because the deed does what they intended to do. But the court may, all other things being favourable, rescind the document. So the trustees have made a disposition that they tended to make, but by an oversight have ignored the tax liability. And they've gone, they've gone from A to B, when it would have been better tax-wise to have gone from A to C. They won't be able to get directly from B to C by rectification, but they can get back to A by rescission. And that's what happened in Kennedy. The intention was to do what the deed did. So rectification was refused, but rescission was allowed. Our next slide, Tom, if you'd be so kind, I don't think I'm getting any more control, is on Freedman and Freedman. In this case, father had lent daughter Melanie money to buy a house and then waived the loan, making it a gift. She then wanted to move to be near the school where she worked as a dinner lady, but she didn't have the money to buy another house. She settled the properties into a trust at his request, under which she was life tenant, and there was a power of appointment in favour of a discretionary class comprising of her son, her brothers and sisters and their issue, with power to add beneficiaries. Subject to those provisions, the property was held for her son, a minor. Now, there were statements from all the family and from the accountant corroborating Melanie's evidence, underlining the importance of compelling evidence in these cases. The purpose with the trust was to protect her against predatory men. It was not intended that she would be able to keep both houses. And the trust was subject to an agreement by her to repay the loan to buy the second house out of the proceeds of the first once it was purchased, as the father wanted to maintain equality in his provision for his children. The mistake that was made was a surprisingly common one. So the case is authority for other cases in which this mistake is made. The accountant failed to appreciate that following the 2006 tax changes, the transfer into the trust was a lifetime transfer into a relevant property trust chargeable at 20%, even though Melanie had a life interest, and there would also be 10-year charges. The Revenue opposed the application and queried some of the evidence, but agreed to a trial on witness statements rather than testing that evidence, which was helpful to the outcome. And they said it was made for family reasons, not tax reasons, and there was no discussion of tax consequences. So Melanie understood. So Melanie hadn't made an active, distinct mistake, but had merely been ignorant. She also saw a letter from the account to her father, which made the mistake, failed to identify the tax liability. And the judge accepted on the basis of that she had made a tacit assumption that entering into the settlement would not create an impediment to her repaying the loan. And in fact, the tax burden did create that impediment. So that's how the judge got there. This is therefore a helpful case on whether unawareness of a tax juggernaut is mere ignorance, or is a tacit, which doesn't engage the jurisdiction, or is a tacit assumption which amounts to a distinct mistake. It's been re-examined in the recent Hartogs case, where it was followed, and in the recent Mackay and Wesley decision of Deputy Master Henderson, where it was distinguished, and I'll come to those at the end if I race along fast enough. It's worth noting, again, that this is another case where the person who made the mistake, as in Wright and Nathwest, and also more recently in Hartogs, had actually had advice correcting the mistake. And the blind spot that they nonetheless had was not a reason to refuse relief. The judge also rejected the lack of centrality argument, because this was a family transaction rather than a tax-driven transaction, because the tax prevented the thing working, and held it was unconscionable to leave her with the loan obligation and the tax charge, accepting that the loan would be enforced. So it was granted in the face of HMRC opposition. And indeed, it's notable that the Revenue said it'd be odd if the Supreme Court, while restricting hastening bath so as not to apply where trustees were not in breach of duty, but relied on mistaken advice as to tax from professional advisors, restricting hastening bath. But then he said this new jurisdiction of Revenue said must be more stringent, but the judge rejected that and said, no, that's wrong. The jurisdictions are simply established by different lines of authority. So again, confirming the net effect is Pittenholt took away with one hand and gave us mistake with the other. Next slide, please. The Revenue also opposed the application in this one, 2016, Vandermeer and Goldman. In this case, witnesses were heard and cross-examined at a full trial, by the end of which there was no real dispute as to the facts. Again, 2006 changes were missed. I won't go into the facts in full because of time is racing along. There was an agreement between the couple that the wife would transfer her interest to the husband, and then he would settle it in because that would work better for tax. And it was argued that that was a contract. And again, this underlines this point I've made about the equitable jurisdiction. If it was a contract, then since the Great Peace in 2002, you can only declare a contract to be void for mistake on the narrow common law grounds, no wider equitable jurisdiction. But the court held that it wasn't a contract. In fact, that the wife had transferred the property to the husband, subject to a trust, and used resulting trust analysis to avoid that conclusion. Other interesting point about this case is the Revenue withdrew a submission in the light of the developing Supreme Court law on illegality. There are dicta in Pittenholt which say that if it's an artificial tax avoidance scheme, you're not likely to get relief if it goes wrong because it serves you right. The Revenue withdrew their submission about that in Vandermeer, but they did make the submission that the parties had taken the risk of budget provisions of which they were unaware becoming legislation and changing the law. And the judge rejected that submission, said, they just made a mistake about the tax effect of the transaction. In offshore cases, the Jersey and Cayman courts, to name but two, have shown themselves ready to rescind quite aggressive tax planning arrangements where they've gone wrong. Onshore, public policy is likely to cause one more difficulty in relation to an aggressive scheme. But this public policy objection, in my view, is limited to a case in which, because the tax planning was not vanilla tax planning, because it was a little bit Raspberry Ripple, there could not really be said to be a mistake at all about the tax liability, because the participants always knew or should have known, and which the court of law is translated into, look, these schemes, that you're running a risk that the scheme's not going to work because it is, there's no such thing as free lunch. This scheme was so very Raspberry Ripple that you must know there's a risk, therefore you haven't made a mistake when that risk turns into a reality. So those are some examples of decisions in which the jurisdiction has been exercised. And on the next slide is a case from Guernsey, Gresham RBC. Before one launches, this is one that went wrong. They thought they might be okay doing it over in Guernsey, but the Revenue applied to be joined, got refused, went to the Court of Appeal. The Court of Appeal in Guernsey granted them permission to be joined, and then they had the hearing, went back for the hearing with opposition. And this is an unreported judgment of the bailiff in Guernsey, but you need to be sure that you can deal with it in case the Revenue or the court say, what about this one? Mr. Gresh had asked the trustee of his pension fund to make a lump sum distribution to him, having been wrongly advised that it would be tax-free. provided that it was not remitted to the UK, but that was wrong. And the court refused rescission of that for 3 reasons. One, it said he had a direct contractual claim against his professional advisors. I think that's wrong, putting the cart before the horse. 2, no other parties, this is the critical thing, on the court's view of the matter, no other parties, such as other beneficiaries of the trust, were affected. This was not a mistake where other beneficiaries would be deprived of assets. And the court said it was unfortunate he'd have to pay the tax, especially if he couldn't pursue his tax advisor for any reason, but it wasn't unconscionable for him to retain the proceeds against the pension trustee. And the court contrasted that with Pitt, where the disabled husband would have been deprived by tax of the funds he needed to provide for his needs for the rest of his life. So the court took the view that it wasn't enough that there was an unintended tax charge in itself. His Honour Judge Hodge took a different view from that in the Hartogs case we'll come on to. And so you can always deploy Hartogs to answer this point. But generally speaking, the answer to Gresh, I think, it's pretty certain to lie in the fact that it's not just the fact that a tax charge has been incurred. It's the fact that the unconscionability lies in the fact that because a mistake was made, but as to tax, but for which the appointment, the advancement, the disposition to beneficiary A would not have been made. Because of that mistake, beneficiaries and the discretionary class B, C, D, and E have all been deprived of their potential for benefiting under the settlement. So there's your unconscionability. That didn't apply apparently in Gresh. So that, I would say, is the answer. On the next slide, 21, Tom has a couple of cases which are to be contrasted with that. And Stephanie, if you could hand back to Tom just for this slide, please, I'll be grateful. Thank you.
Thanks, Piers. Yeah, the St Anne's trustees case happily, I think, puts Gresh into a box. There, the Guernsey Court of Appeal took a favourable view towards the application of Pitt and Holt. At first instance, Her Honour Hazel Marshall QC, Hazel Williamson QC, when she was in practice over here, had refused rescission. It was a QROPS, a qualifying recognises it, overseas pension scheme. And rather oddly, the mistake was a mistake which you would have thought might not have been made. The principal client, whose pension fund it was, went to his actuaries and said, I want to start drawing down on my QROPS. They said, well, you've had so much money out on a loan, you can't draw down until you've repaid the loan. He said, well, can I repay it by putting properties, residential properties, into the QROPS? I'd like to, but here's a Daily Telegraph article which says I can't. And Barnett Waddington rather surprisingly said, yes, you can. And his solicitors also didn't pick up the point. But obviously, residential properties inside pension schemes is a bit of a no-no and triggered a £1.8 million tax charge. So that was what they needed to unscramble. And Hazel Marshall had got her futter mixed up with her Pitt and Holt, if you like, and had, because this was a true Hastings Bass, but she drew unconscionability from the rescission in Pitt and Holt into the Hastings Bass regime. And she was told that that was wrong by the Court of Appeal. You don't have to do an extra unconscionability test if a serious mistake has been made, which would bring the Hastings Bass jurisdiction into force. She also rather surprisingly said that £1.8 million charge of tax is not ruinous. That's a nice shows where she stands on these sort of figures. But the Court of Appeal took a rather more pragmatic view. So, well, the 1.8 million is bad enough, surely. And so that's it was still a serious mistake. And also there they reaffirmed the fact that the mere fact you can sue the advisors is not a reason to prevent Hastings-Bassell or rescission from taking place. And they referred back to Walker himself, who said that that was as a matter of principle in Pitt and Holt. It was a matter of principle in Pitt and Holt because it was pretty clear that an IFA who'd advised 20 more years earlier wouldn't be good for the money. It's less of a point of principle when there's a solicitor with insurance policy, perhaps one might think. But luckily, it's a point of principle, and that's shown by the Jersey case of Onorati, which I only remember because Onorati sounds like some group of people that have been dreamed up by Dan Brown for the Da Vinci Code. The Onorati line up with the Illuminati, but it's a helpful way for me to remember the case. So that was St Anne's trustee, a good case to help us along. One of the interesting things about it, though, was that I noticed in reading it through that the Court of Appeal there relied on a speech that Lord Walker gave to ACTAP's annual lecture, and he gave it about 4 or 5 years ago, and about the sad way that trusts were in decline in this country. And I remember asking him at the end of that speech, don't you feel that you've been nailing a few nails into the coffin by your decision in Pitt and Holt and v. Futter? And he looked rather lugubrious and said, well, yes, maybe that's true. The good thing is that ever since then, we've been prizing those nails out. So let me pass on to Piers with the next slide.
Thanks, Tom. If you could, just thank you very much for that. I'm just going to go through these very quickly because I want to get on to the two most recent cases in the time we have left. You can do this, provided the delay hasn't prejudiced anyone. You can take your time. Pitt and Holt, settlement 94, parties aware of the mistake, 2003, application not till 2010. You can get it, it didn't happen in Van der Murray, but you provided the evidence, documentary evidence is convincing, or there's no reasonable prospect, you can see that the witness statements hold together in such a way as to be convincing and not something that's going to be shifted in cross-examination. You can get a decision summarily, and you generally do get decisions summarily on these applications. And as we've said, this is something trustees can use as well as individuals. The next slide, thank you. So we'll now get on to Hartogs. I've already mentioned how His Honour Judge Hodge said at paragraph 27 that the unconscionability lay simply in the tax charges that arose by reason of the mistake. So that's a useful answer to Gresh, because he was sitting as a High Court judge and first instance authority that unconscionability lies in the tax charge itself. It's also interesting, this case, on the difficult questions as to the distinction between mere ignorance and tacit assumption. I've mentioned the other respect in which it's interesting, which is that the mistake maker was actually told of the mistake, but just had a blind spot, and that didn't stop relief. But on mere ignorance, on the one hand, no relief, tacit assumption, relief. In this case, Mr. Hartogs had put his purchases of house in St. John's Wood and a classic car collection in an envelope. And unfortunately, he discovered in that envelope a hefty tax bill, as he had become domiciled in the UK rather than abroad when he did it. The envelope transaction, with which you'll be familiar, was of course tax driven, and the judge accepted that in that context, courts are prepared to view the absence of knowledge of a particular tax charge as a tacit assumption that there would be no such charge, rather than mere ignorance of such a charge. And this was something that can be readily inferred when the transaction is tax driven. So in a way, the bigger the mistake, the better. You've actually looked at it and you've got it wrong, rather than you've not been thinking about it. On the other hand, on the next slide, we have Deputy Master Will Henderson in Mackay and Wesley, which he held, obiter, to have been on the other side of the line. The unfortunate Ms. Mackay was appointed trustee of a trust that had embarked on a doomed voyage on a round the world scheme. which rendered her, as the new trustee, liable for a tax charge of 1.6 million CGT, although there was only £61,000 left in the trust. So that was a big oops and a big ouch. But in spite of that, Henderson held that the jurisdiction didn't even apply because this was an appointment of a trustee as opposed to a disposition of property. And he said it was also contractual because she gave consideration for the appointment by giving an indemnity to the previous Mauritian trustees. He went on to, however, to review Friedman, which was the first case I've mentioned, talking about Sonia Proudman's case, talking about mere ignorance and tacit assumption divide, which is a very difficult one. And then Hartog's he reviewed also. He held that where Sonia Proudman appeared to be taking a pretty broad view of what amounts of tacit assumption, she was merely reciting Claire Stanley's submissions. In his case, he decided that Ms. Mackay's belief that her father would not ask her to sign documents that would put her in danger, very general, although that could be said to be a tacit assumption that acceptance of the appointment would not have adverse effects, which may be said to include adverse tax effects. That was not a sufficiently distinct tacit assumption. It was too general. And he regarded the line of cases which I've described, including Pitt and Holt, he said, itself, as falling very close to the line between mere ignorance and tacit assumption. So it is possible that the revenue will decide to take up the cudgels on this issue in the future. We may have to litigate whether there is a significant difference in equity between a trustee crossing the road without looking left and right and getting mown down by a tax juggernaut, and a trustee who does look left and right but somehow fails to see the oncoming tax juggernaut. The present distinction is, I think it has to be accepted, not an easy one. It will always be the case, as I've said, that trustees would not have entered into the transaction if they knew then what they know now, or they wouldn't be seeking to undo it. Does it make a difference to the unfairness on the other beneficiaries of the donee retaining the property mistakenly appointed or advanced, whether the trustees thought very carefully about tax and just got it wrong, or did not think about tax at all? In terms of the unfairness on the other beneficiaries, I think there's a decent argument that it shouldn't make a difference, but that may be a watch this space. So thank you very much for listening. We're going to go on to 1 minute.
Piers,
yes,
you've got a minute, Piers. I'm not sure if maybe you can't hear me.
Yes, I can hear you.
We got just 1 minute before I think we shut up.
I've got one question on the Q&A. Take that, Tim.
There's one excellent question which came in. I mean, a lot of good questions came in, but one particularly excellent, I thought, was that I said that a trustee isn't acting in breach of trust if he's taken advice. That's what Refata decided. And somebody's come up with a rather splendid idea that you can get around that if the trustee has, in looking for advice, asked the wrong question. And I think that's quite a interesting line to pursue. I mean, certainly if the trustee says, well, asks for advice specifically about income tax and capital gains tax, and gets that advice, but the real horror is inheritance tax and he hasn't asked about it, then that would, the fact that he's taken advice on other taxes also